What's going on, everyone? I hope you're having a beautiful day. We have a new update here on the court case with the CEO of SafeMoon, John Karony. This coming from a post by Live for Ford over on Twitter. Shout outs to them. They have been regularly posting these court update documents, so it seems like a very reliable source if you want to know what's going on the moment over on Twitter. And before I do dive into this, guys, I do want to tell you I have a couple different TikTok channels. One that is called Crypto Atlas, if you want to check that out. I also have AI.crossover. There's a link in the description down below. I've been putting a lot of time and effort into this. I'm really trying to grow it, and I'm just having some difficulty in the discovery over there. So if you guys are on TikTok and you would like to show your support and you'd like to see what kinds of renderings I come up with the AI programs of these different shows, then I would love it if you guys drop me a follow. And that being said, let's go ahead and get right on into it. Dear Judge Cho, the government respectfully writes in response to defendant Braden John Karony's December 4th, 2023 renewal bail motion. For the reasons that follow, the defendant's motion should be denied. Number 1, background and procedural history. On October 31st, 2023, a grand jury in this district returned a 3-count indictment charging the defendant and 2 co-defendants with 1 count of securities fraud conspiracy in violation of, and it gives you the code, 1 count of wire fraud conspiracy, and 1 count of money laundering conspiracy for their roles in a series of fraudulent schemes concerning the digital asset issuer SafeMoon US LLC. The defendant was arrested that night at Salt Lake City International Airport. On November 3rd, 2023, the Honorable Daphne A. Oberg, Magistrate Judge, District of Utah, found that the, quote, threshold was met for a detention hearing and set for a hearing for November 8th, 2023. On November 8th, 2023, the court ordered the defendant to be released pending trial, the release order. There's a footnote here, and it says the government incorporates by reference in its November 8th, 2023 detention memo, including its recitation of the offense conduct, the instant indictment and the defendant's arrest. The government promptly moved to stay and revoke the release order. On November 9th, 2013, the Honorable LaShawn D'Arcy Hall, United States District Judge, ordered a stay of the release order. I believe this is obviously a typo. Should say 2023, not 2013. On November 13th, 2023, after oral arguments, Judge Committee vacated the release order and ordered the defendant to be removed to this district in the custody of the U.S. Marshals Service. The defendant now seeks his pretrial release, claiming that he is neither a risk of flight nor a danger to the community. Because the defendant has not offered a bail package that addresses Judge Committee's well-founded concerns about his risk of flight, and for the reasons set forth below, the court should deny the defendant's motion. In vacating the release order, Judge Committee stated, with respect to the defendant, it seems utterly clear the defendant is a person with access to substantial amounts of money based on the government's proffer. We're talking about money that it would be potentially easy for the defendant to access, but hard for the government to trace or track. And we don't have any of the moral suasion that would be associated with meaningful security posted by solvent sureties who have the kind of relationship with the defendant that would bring the moral suasion that I think we all would want to see. Renewing his motion for bail, the defendant puts forth a new bail package nearly identical to that presented to Judge Committee, but with the proposal of his parents as sureties. For the reasons set forth herein, the defendant's bail package fails to address the concerns identified by Judge Committee when the court denied him bail in November, and this package is insufficient to ensure his appearance in the Eastern District of New York. Among other things, his proposed suretors do not have the kind of relationship with the defendant that offers the moral suasion necessary to dissuade the defendant from fleeing. Number 2, argument. A, the defendant has not shown that he is not a risk of flight. As set forth in the government's November 8th, 2023 detention letter, The defendant has primarily resided in the United Kingdom since SafeMoon's launch in March 2021. He is engaged to marry a citizen of the United Kingdom and plans to get married there. The defendant has not and cannot dispute these facts. Instead, he claims that his return to the United States, particularly after being interviewed by the FBI in late 2021, establishes that he is not at risk of flight. But that assertion is undermined by the fact that the defendant told others after his interview with the FBI that the FBI was closing its investigation. This is reflected in the following November 4th, 2021 electronic message exchange between the defendant and his co-defendant, Thomas Smith. In this communication, you see Smith says, "How goes NYC?" John Karony responds, "It goes well, dude. May have a few items for ya to work on." Smith responds, "Baller. Let me know." Karony responds, "FBI stuff went really well. The matter is now closed." Smith responds, "Hype." Smith then responds, saying bittersweet and that the FBI is a nothing burger. Feeling good there at least. Although the defendant has repeatedly argued for bail, claiming that he freely traveled to the United States while under investigation, his own statements make clear that he did not believe that to be true. In the defendant's view, there was no reason not to return to the United States because he was under the mistaken belief that the government's investigation had been closed. The defendant is now in a materially different posture. He's under indictment and faces charges that together expose him up to 45 years in prison if convicted, and likely tens of millions of dollars in potential forfeiture and restitution. The defendant's incentive to flee is great. The defendant also claims that he has long-standing ties in Utah and Florida, that his pretrial detention has prejudiced his ability to consult with counsel, and that he is not a danger to the community because a restructuring officer at SafeMoon overseeing the company's assets and operations and proposed conditions would preclude him from dissipating assets. In fact, the defendant's ties to Florida and Utah have diminished materially over the last 2 years, during which he primarily resided in the UK and became engaged to a UK citizen. As for the defendant's purported inability to adequately consult with counsel, the government notes that the detained defendants in this district regularly consult with their counsel to, among other things, prepare for trial. The defendant's position is no different from every defendant in custody in the Bureau of Prisons and does not provide a basis for release. Finally, the defendant's claim that he is not a danger to the community who could dissipate assets in light of SafeMoon's restructuring officer and other proposed pretrial conditions is also inadequate. As alleged, SafeMoon was an enterprise used by the defendant as a vehicle to commit fraud and enrich himself and his co-conspirators. Any involvement with SafeMoon, even if guided by a purported restructuring officer, could lead to further harm. And SafeMoon, and as for the dissipation of personally held assets, the defendant could easily evade his proposed conditions of release by having others access digital wallets maintained outside the U.S. and around the world on his behalf and at his direction. B. The defendant's proposed bail package is wholly inadequate. There's a footnote here. I'm going to read this part first. As he did with Judge Committee, the defendant again argues that his application for a new U.S. passport does not evidence a risk of flight because he was only seeking to replace a damaged passport. Given the defendant's failure to proffer the kind of damage to his prior passport that necessitated a replacement passport, the government is unable to adequately respond to this assertion. Even if the court agreed that the defendant could be released from custody subject to a bail package with certain pretrial conditions, the defendant's proposed suretors, collateral, and bond are wholly inadequate to ensure the defendant's continued appearance for the reasons that follow. First, the defendant's proposed suretors. His mother, Jennifer Karony, and his father, Bradford Karony, are both fact witnesses in this case. In or about October 2022, Jennifer Karony contacted the Federal Bureau of Investigation, FBI, and began providing information about the defendant and his SafeMoon-related conduct, some of which Ms. Karony described to the FBI as criminal. Since that time, she has provided information and documents related to SafeMoon and the defendant's conduct and expressed concerns that SafeMoon was a fraudulent enterprise and that the defendant had misappropriated millions of dollars of investor monies. Ms. Karony continued to provide information to the FBI voluntarily up through the time of his arrest. Second, the government is aware that prior to the defendant's arrest, both proposed sureties were effectively estranged from the defendant, having not spoken to him for approximately 19 to 20 months. During that time, the defendant and certain entities he controlled sued his mother, Ms. Karony, an entity they jointly controlled called Emanation Communications Group, LC or ECG, and others in Utah State Court in August 2022, alleging breach of contract, fraud, conversion, and unjust enrichment in connection with the operation of ECG. The defendant alleged that he had funded ECG with $5 million, but that Jennifer Karony, his mother, had, among other things, misused the $5 million capital contribution for her own non-ECG purposes. An individual who the defendant has sued and has been actively litigating against for more than a year surely cannot have the moral suasion over the defendant that Judge Committee sought and the law requires. Third, in addition to the $5 million the defendant used to capitalize ECG, he has sent significant additional monies, both fiat and digital assets, to both Jennifer and Bradford Karony during the relevant time period, which transfers are consistent with the pattern of transactions used in furtherance of the misappropriation of investor monies and laundering alleged in the indictment. For example, Jennifer Karony maintains multiple accounts, including an account in her name at a Utah-based bank, at which the defendant also maintains multiple accounts. The defendant, Jennifer Karony and Bradford Karony, also maintain accounts at the same domestic digital asset exchange, with all their accounts opened within weeks of each other. Records received from the Utah-based bank show internal transfers from accounts controlled by the defendant to accounts controlled by Jennifer Karony. Those records also show money sent to accounts controlled by the defendant from the digital asset exchange where he and his parents maintain accounts. There's a footnote here, and then we'll continue on. Prior to the November 13th, 2023 telephonic conference that took place before Judge Committee, Bradford Karony publicly stated on the public line in sum and substance that he was appearing as a spokesperson for the family against the defendant, Braden John Karony. This is a summary of information provided by Ms. Karony, which may be supplemented at a later date. The summary is provided for the limited purposes of assisting the court in assessing Ms. Karony's suitability as a surety. The government understands that in light of this prosecution, the parties have recently decided to settle the action. In addition, records received from the domestic digital asset exchange show Bradford Karony receiving at least $1 million in digital assets from digital wallet addresses the government believes are controlled by the defendant. These facts suggest that the proposed suretors may be indebted to the defendant, a fact that makes them ineligible to serve as his suretors. Moreover, given the defendant's effective estrangement from his family prior to his recent arrest, the defendant could in fact be incented to flee and leave his proposed suretors with the burden of paying the government the amount of any bond. For these reasons, the government submits that neither Jennifer Karony nor Bradford Karony has the requisite moral suasion over the defendant, an individual to whom they are arguably indebted for millions of dollars. And it goes on here saying, affirming district court's denial of bail application and holding that defendant's mother proposed suretor's willingness to stand as her son's suretor may have evidenced strong maternal devotion, but the record fails to evidence the sort of filial respect necessary to support an inference that Hill would appear for court and conform his conduct to the law rather than jeopardize his mother's home and assets. In addition, the defendant's proposal to set a bond amount at $500,000 and to secure the bond with a Kansas City residential property is similarly inadequate. The government's investigation has shown that the proffered Kansas City residential property owned by Mr. Karony, indirectly through a wholly owned limited liability company, is inadequate to secure any bond. As the defendant previewed, The defendant's purchase of the Kansas City property is entirely consistent with his other uses of misappropriated investor monies, as alleged in the indictment. The government's investigation of that property's acquisition continues, but records relating to that transaction indicate that it was acquired, at least in part, with proceeds traceable to the charged crimes. As for the $500,000 proposed bond amount, the defendant, as alleged, personally profited in the tens of millions of dollars. Footnote here, were the court to find a $500,000 proposed bond sufficient, which it should not, the government would request a nebia, or bail source hearing, pursuant to United States versus Nebia. Defendant must disclose the source of funds used to acquire the assets used to post bail and demonstrate those assets were obtained with legitimate funds to be released. And it goes on here, $500,000 is thus inadequate to deter the defendant from violating his bail, given his access to digital assets that far exceed the amount. Respectfully submitted, Breon Peace, United States Attorney. And there you go. Let me know what you guys think about this down in the comments below. Goes into more detail in this video about the degree of the relationship and the back and forth that took place between John Karony and his own mother. Very interesting stuff. So what do you guys think the court is going to respond? What will be their response? What are your thoughts? Tell us down in the comments below. And once again, if you do use TikTok, would absolutely be greatly appreciated if you could drop me a follow on ai.crossover. I'm trying hard with these videos, and I don't know why. It just feels like I'm being capped out right about 200 views on every video that I'm doing. Thank you to my Patreon supporters. Double shout out thank you to We Love, Victor Vegas, and SafeMoon X for being higher level patrons. Thank you to my YouTube members for your support as well. God bless. We'll see you in the next episode.